Welcome. Thank you for joining today's distinguished speaker. We'll be starting momentarily. Great, welcome. As you filter in, we'll be starting momentarily. We're just waiting for people to filter into the webinar. All right, let's get this show on the road. Welcome and thank you for joining. Welcome and thank you for joining today's Distinguished Speakers Series at Bakersfield College, hosted by the Bakersfield College Student Government Association, BCSGA, and the Office of Student Life in collaboration with the Levin Institute for Lifelong Learning. These webinars and many other student-centered events are only made possible by the BCSGA KBC Student Services Sticker Program, which students have the option to purchase at the time of registration. For more information, visit bakersfieldcollege.edu/BCSGA and also to meet our collaborating partners for these events. Just a few housekeeping notes before we begin. This webinar is streamed to various social media outlets and will be recorded and made available up to 2 weeks after the event for students. Closed captioning is made available by clicking the closed caption button at the lower part of your screen. This is a webinar event, thus you will not be able to show your video or talk through your mic. The chat feature has been disabled for this webinar. All inappropriate questions or comments in the Q&A button will be removed immediately. To pose a question in the lower part of your screen, you will see a Q&A button. This is to submit your questions to us. We will review the questions and ask them at the end of the speaker's presentation. We may either respond to the question live or respond to it via the module. The Distinguished Speakers Series brings community leaders from around the world to Bakersfield College, whose achievements have had national or international significance. Each webinar was proposed to BCSGA by either a department or a faculty member. Collaboration between many entities on campus make these events successful each year. The events are free and open to the public. All events this year were scheduled via the Zoom virtual platform. For more information on future speakers for next year, please visit bakersfieldcollege.edu/student-events/DSS. Please note today's webinar is recorded. In case of technical issues, please stay online as we work through them. In the case of disconnection, please join us on Facebook Live at facebook.com/SGABC. If you ask questions during the presentation, please submit them in the Q&A module so that the moderator will be able to respond or ask live. At the end of our speaker's presentation, you may also post questions on our social media post as well to be captured there. As a reminder, we do have another presentation at 2 p.m. Please visit bakersfieldcollege.edu/student-events/DSS to register for the next Zoom. Now, without further delay, I welcome you, the one, the only Professor Reginald Williams, Professor of Philosophy, to introduce today's distinguished speaker.
Thanks, Nikki. One quick question for Nikki, actually. You said the next talk's at 2, the next one's at 6, correct?
My apologies. Yes, it's at 6 o'clock.
Yeah, we're doing 2 talks today. This one, of course, and then the next one, the second one, the final one is at 6 p.m. tonight. So I just wanted to make sure there's no confusion there. All right, thanks again, Nikki, for handing it over. So I want to welcome everybody to the Distinguished Speaker Series, as Nikki already did. And I also want to welcome to you what is also the 7th annual Norman Levin Lecture in the Humanities. I'm the director of the Levin Center, so my role today is to introduce our speaker, and also I will be moderating the question and answer session, which Nikki nicely already laid out, so I think we're already clear on that part, so I'll leave that for that. I do have a couple of thank yous, and then later tonight when I introduce the 6 p.m. talk, the thank yous will be a little bit more numerous and developed, but I want to keep it kind of quick right now. But I do want to thank Nikki, Benny, and Danielle at the Office of Student Life and the Student Government, the Distinguished Speaking Series, because we've collaborated on bringing our amazing speaker today. So thank you to all three of them and their entire staff. Also, I want to thank my administrative assistant, Miriam Valenzuela, who is amazing, and I would not be able to do my role in the Levin Center without her. And then finally, before introducing and thanking our speaker, I want to mention, definitely, I always want to thank Norman Levin. Norman Levin, I'll say more about him tonight, but Norman Levin was an amazing philanthropist in town, and he was a dermatologist for 50 years locally. He taught at USC, for that matter, dermatology, and he donated an amazing amount of money to Bakersfield College that allows for all sorts of programs that I'll mention more of tonight, but certainly today's talk and all of the Levin Center events would not happen if it were not for Norman Levin. So always a humongous thank you to him. Again, I'll have a few more thank yous tonight, but I think I'll leave the thank yous there for right now, other than thanking our amazing speaker and doing some introduction. So today I am extremely honored to introduce Barry Scheck. Barry Scheck, truly to do a full intro on Barry Scheck would be the time of his talk. So I will not do that, of course, but he's incredible and there's so much to say. A few just kind of bullet points, and then we'll hear from him. So Barry Scheck is considered one of the 100 most influential attorneys in the United States. He holds a bachelor's degree from Yale. He holds his law degree from Berkeley. He's a professor of law at Cardozo School of Law, Yeshiva University. He's a partner of NSB, the nation's leading civil rights law firm. His work is absolutely pioneering in the use of scientific evidence in trials, both civil and criminal, specifically DNA evidence. He's an expert on the area. And his work has done an amazing job of, if you will, policing, although he might not like that word choice, but holding accountable for sure crime labs across the country when they have been inept in their use of scientific evidence. In 1992, Barry Scheck co-founded the hugely impactful Innocence Project, which, depending on the sources you look into, will tell you over 300, as many as 375 wrongfully convicted persons have been they've been released, they have been paid restitution, their records have been expunged because of Barry Scheck's work. And specifically, many of them have been incarcerated on death row. And so quite literally, Barry Scheck's work has saved some lives, innocent lives. Barry Scheck's a published author of the book Actual Innocence. His work has inspired a film, Conviction. He's the commissioner for the New York State Forensic Science Review Board. He's represented several high-profile persons, Hedda Nussbaum, Louise Woodward, Abner Louima, and O.J. Simpson, among countless others. And he's received so many awards, I will only name two: Thomas Jefferson Foundation Medal in Law and the Thurgood Marshall Award. Again, I could not be more honored to present to you Barry Scheck. Without further ado, let's hear from him. Thanks, Barry.
Thank you so much, Reggie, and it's a real privilege to be here. I've titled this talk Innocence, Justice, and Race. And what I'd like to do is just give you I'll start with the specific kind of case that the Innocence Project does that I think is kind of relevant to explaining the big picture. But today I encourage any questions about the Derek Chauvin case, because I've been following that, as I'm sure you all have, with great interest, and I feel very informed about it if you have any questions. I think it's extraordinarily important prosecution, and that's been handled extremely well. So just to give you a basic notion, looking at an individual case that goes, one of our very, very first cases that we received at the Innocence Project is our friend Archie Williams, who was wrongly convicted of a sexual assault, forcible sexual assault in Baton Rouge, Louisiana. And that's him getting out. The crime took place in 1982. And here's how it all starts for us and at the Innocence Project and other innocence organizations across the country. So here's the letter that Archie wrote. Dear Mr. Barry, my name is Archie Williams. I'm 35 years old. I'm serving a life sentence for rape and attempted rape, a Baton Rouge woman that I know I didn't commit. As the years go by, I sit here year after year. It's like no one cares. You have no outside help. People let you down and give up on you after about the first 2 years. Then all you have is prison life. But by the grace of God, I'm still holding on, hoping and praying in faith that someone will answer my letter and help me. And I have mailed my case to many places for help, but no response. Talked with everybody I could think of. I know if only one of the person picked up my case and read it, they would know that I'm not guilty, I'm innocent. If I could get a DNA test, it would prove my innocence. It's all about the rape of a woman, a wife of a big-time Baton Rouge attorney. That's why no one wants my case in Baton Rouge, because everybody knows the man. I was last denied in Middle District Court. I've been here in Louisiana State Prison. That's Angola. It's known as the Farm. It's extraordinary place. Many movies have been written about it for 12 years. No one won't help me because I don't have any money. I'm trying hard because I know I'm innocent. I found you by talking to a friend. I know that people must write you all the time, but if you could or would please find it in your heart to help me. I would appreciate any help that you could give. If it's only you reading my case in closing is a closing argument of my case, thanks, may God bless you and your family, Archie Williams, which we received on March 19th, 1995. So that's Archie, and I'll get back to that in a minute. I'll get back to it right now. So what happened in Archie's case, and you can see the young woman in the middle is Vanessa Potkin, who was head of post-conviction litigation at the Innocence Project and was the very first lawyer that we hired right out of Columbia Law School. And to her left is Emily Maw, who for years ran the Innocence Project in New Orleans, and now a sign of the times, runs what they call a civil rights division, but it's generically known as a conviction integrity unit in the New Orleans district, the Orleans Parish District Attorney's Office, which is now run by a former criminal defense lawyer and a former chair of the New Orleans Innocence Project, Jason Williams. It is a wonderful progressive office, and it's a trend that's sweeping our country. Now, in Archie's case, what he said was exactly right. He was identified by a woman in Baton Rouge from, a photo array that had problems. At first, she didn't identify him. I won't get into any of those issues. But in Archie's case, we not only tried to get DNA testing, and we were denied in the courts, and the district attorney in Baton Rouge refused to consent to it. But we then had to get a statute passed in New Orleans to allow DNA testing to deal with Archie's case. But of course, the DNA testing turned out to the semen in the rape kit came back to the woman who was attacked, her husband. So that was not probative. But the one thing that was always clear is that there were fingerprints in the room where she was attacked, fingerprints and blood, because this was a violent sexual assault. And Archie had a lawyer, a public defender, who, despite lack of resources, actually did a very good job in this case. And when you read this article in the New York Times about Archie's case, you'll see that from the closing argument that Archie referred to in his letter, he said, that closing argument talks about if somebody can only, do something with those fingerprints. And so it was known from the beginning that they didn't come from Archie, but if you could find out the source of those prints, you would be able perhaps to find the person who really committed the crime. And in addition to, there are some scientific problems with fingerprints, but it is still, if properly done, and we need more research to really identify the probative value of the prints. But bottom line, if there is now what they call an automatic fingerprint identification database, just the way that there's a DNA database that's known as CODIS, the fingerprint database is known as AFIS. And so we tried for years and years and years to get Archie's prints, the prints, I should say, in blood from the crime scene into the AFIS database. And then finally, I think this is now 3 years ago, we were able to do it. And sure enough, it was a hit. And it was a hit to an individual who was already deceased, but he had been previously arrested and convicted for 6 other sexual assaults in the Baton Rouge area. Same modus operandi as this case. It was clear that he had committed this crime, and Archie was able to walk out of jail. Now, to some of you, Archie may look familiar because right after he walked out of jail with Vanessa, Emily, and myself, he held a press conference, and Archie, there's a movie called The Farm about Angola prison, but Archie was a great singer. And they asked him, well, what do you want to do next? And he said he wanted to go on the Steve Harvey show. So as a matter of fact, we were able to get him on the Steve Harvey show, and he wanted to sing because he was a wonderful, wonderful singer. And now there's a show that many of you may have seen called America's Got Talent. And great thanks to Simon Cowell, because he took a huge interest in Archie's case, and they did a fantastic production. And I know that there are millions and millions of followers of America's Got Talent. And for those of you that are among them, you will realize that Archie was one of the finalists last year. He didn't win, but he certainly did amazingly well. And so that's Archie. And before the end of this talk, I'll talk to you about what we can do to exonerate more people with the automatic fingerprint identification system, particularly in California. So what is the Innocence Project? What is the Innocence Network? What are we doing? And of course, you know, the mission is clear, and injustice anywhere is a threat to justice everywhere. And we want to free wrongfully convicted people. We want to reform the system responsible for their unjust imprisonment. And we want to confront racial injustice anywhere in the world. And it's an international human right. Every legal system, adversary or inquisitional, and inquisitional just means, you know, it's more or less run by a judge. And a lot of inquisitional systems exist in Western Europe. But any adversary or inquisitional system should recognize a post-conviction right to prove your actual innocence. You didn't commit the crime, and have a viable process in place to provide such relief. And indeed, when we started the Innocence Project as a clinical program, myself and my partner, Peter Neufeld, in 1992 at Cardozo Law School as a clinical program, there was only 1 or 2 states, New York and Illinois, that even had a statute that allowed you to file a post-conviction test. And that's why I mentioned in Archie's case, we actually had to do it. When you look at the Innocence Project, and we like to call it a civil rights movement, you know, we protect the innocent, we enhance the capability of law enforcement to find and convict the guilty party with scientifically reliable evidence. And for those of you who are looking at it, one of the things the Innocence Project really advocated and had a hand in doing is in 2009, the National Academy of Science wrote a report about strengthening forensic science. And it basically said the only validated forensic assay was DNA testing. The 2009 report was a real inflection point, a landmark. I wish I could say that its recommendations had been adopted, but we are still in a struggle to get them adopted. We, for a while, had a National Commission on Forensic Science. The Trump administration abolished the commission. We still have something called the Organization of Scientific Area Committees that is overseen by the National Institute of Standards and Technology, real scientific organization, but a struggle continues there. And I should just mention in passing, because I hope we do discuss the George Floyd case, what's really remarkable about the George Floyd case, and I shouldn't call it the George Floyd case, the Derek Chauvin trial, is that the prosecution, the evidence has been completed. And for those of you that are watching the trial, it was really different than other kinds of cases where the issue of what they are calling positional asphyxia or people die in the custody of a police officer when they're on top of them. Because the scientific evidence that the prosecution put forward, Dr. Tobin, who was the last witness called in rebuttal, who's a pulmonologist, he is, as he said, only testifies in civil cases. He had never testified before in a criminal case. And we should see Dr. Tobin and people just like him going forward, because what he talked about there was truly new in terms of the prosecution of these cases. And I'd like to say clearly that the Attorney General of Minnesota, who organized this prosecution, Keith Ellison, is in his own right a brilliant lawyer, was a criminal defense lawyer, did homicide cases, but he organized an incredible team. He brought in civil lawyers. You might have noticed the person I believe will be doing the closing, who did the opening, Jerry Blackwell, who did a lot of the scientific witnesses, and Steve Schleifel, I'll mispronounce his name. These are two individuals from civil practice who came in to assist the prosecutors in the Attorney General's office. And there were quite a number of other people behind the scenes who also volunteered to help, such as Neil Katyal, somebody you've probably seen on television over the years, who was a former acting Solicitor General of the United States. So the scientific evidence that they put on in this case hopefully is going to be taken up across the country. There should be none of these excited delirium defenses that succeed. And we learned a lot about, what really goes on in these positional asphyxia cases. And it should really dramatically change the way police officers are trained in this country. Short digression. And just in terms of our civil rights movement, what we try to do is triangulate the adversarial paradigm. We try to be non-ideological, focused on public safety, explicitly truth-seeking, and frankly, spiritual, not in the religious sense, but in the sense of justice-seeking. And we look to find win-wins. So much of the legislation that we've put forward in the state and federal system, over 250 state bills passed by our policy department and lots of federal legislation. All of it, we think, improves the functioning of the criminal legal system. Just a quick statement. This is too technical about what actual innocence is. It's not yet, it should be recognized in and of itself as a federal constitutional right, but there are certain ethical issues now that recognize it from the American Bar Association. 3.8 G and H talk about a post-conviction obligation to disclose material evidence of innocence. And if it's clear and convincing, prosecutors should do something about it. It's not formally recognized yet as a constitutional duty, but in my estimation, it will eventually be adopted. And this approach has also started the creation of what we call conviction integrity units. That is, units within a district attorney's office that will work cooperatively in a non-adversarial search for the truth with innocence organizations and defense lawyers. And I've written a lot about this, but these CIUs ought to be run by people that at least have defense experience and report directly to the elected DAs. It's a very important development over the last 10 years. So the innocence movement, just generally, it really started in 1989 when there was the first DNA exoneration in the United States, as DNA evidence began to come into the criminal legal system, where originally it had been a product of medical research, scientific research. We formed our organization as a clinical program, as I told you, in 1992. By 2000, we had innocence organizations at other law schools all across the country. There are at least 3 now in California. One of them, the California Innocence Project, the Cal Western Law School, was among the original groups of innocence organizations that formed our network, led by Justin Brooks. And I think you might, if you saw the Brian Banks Move Me, Justin was played by, there was a prominent movie recently, and Brian is a wonderful guy. He was wrongly convicted of a sexual assault, which robbed him of an opportunity to go to USC and play, frankly, in the NFL, but he's doing great now. Then we've gone on to have a whole series of innocence meetings across the country. We didn't have one last year because of COVID. There are 56 innocence organizations in the United States, as I said, most in law schools, some in public defender offices. There are 13 international organizations, and again, our friend in Cal Western, Justin Brooks, organizes something called Red Inocente, which covers Mexico, Central America, Latin America, all in one group. I should mention also the Northern California Innocence Project, which is terrific at Santa Clara, and the Loyola, I think they're going to call it soon, the Los Angeles Innocence Project, out of Loyola Law School in Los Angeles. There have been, as Reggie mentioned, 375 DNA exonerations in 1989. And we track those because in something like 47% of those cases, because of the CODIS database, I think, and the nature of the evidence, not only have people been exonerated, but the person who really committed the crime has been identified. But the place to look to get the full sense of this is the registry of exonerations, which is being curated now at University of California Law School at Irvine, although it has editors from Michigan State, but it is at UC Irvine, and run by my friend Simon Cole, who's an expert in fingerprints, and we'll get to that in a second. But when you look at the registry, they look at DNA and non-DNA cases. And the way they define an exoneration is the best way the legal system really can, which is you were convicted, your conviction was vacated based on new evidence of innocence, and then you were either not retried, you were acquitted after trial, or you were pardoned by a governor. And since 1989, because we use that as the place to sort of begin tracking what is the innocence movement, the registry has documented 2,774 of these exoneration, and you just go there to the website and it goes up every day. And more than 24,840 years lost is maybe another way to look at it. Factors involved in wrongful convictions, 75%, certainly an eyewitness identification, mistaken identification. But a lot of that is just, it is still a leading cause of wrongful convictions, but the early data was skewed that way because of the prevalence of DNA testing. Unvalidated forensic science, the National Academy report again is critical for you to look at, 50%. False confessions or admissions, 25%. Incentivized informants, that is 20%. Jailhouse informants, huge scandal in Orange County, California, as I'm sure, I hope you know. And Reggie was kind enough to mention the movie Conviction. which is terrific. And that's Betty Ann Waters, who got her brother Kenny out of jail. Go back and get this off Netflix. I think it's a terrific movie. It was directed by Tony Goldwyn, who you may know as President of the United States from the Chandra Rhimes series Scandal. But he's a terrifically talented man and a great director as well as actor. But the star, Betty Ann Waters, who is the sister that helped get Kenny out of jail, is played by Hilary Swank, and she's terrific. Sam Rockwell, also an Academy Award winner, played Kenny. And Melissa Leo, an Academy Award winner, plays the cop that played a bad role in this. And on it goes. And I think you'll find that movie very entertaining. And the one thing I'll say about it, we did not change one name, right? So it's more than just based on a true story. There it is. Inadequate representation of counsel. It's 20% doesn't really capture it because we don't really have good measures. It's much larger and more serious than that. Prosecutorial misconduct, 20%. The very famous case involving Michael Morton, who was wrongfully convicted of killing his wife in Texas. And it was a prosecutor hid exculpatory evidence. Years later, we were able to not only find that evidence, but at the first time ever, we were able to get what they call a court of inquiry, a citizens grand jury in Texas, and got the prosecutor hid the evidence, was convicted of contempt of court, and sentenced, unfortunately, to it's a misdemeanor only. He did 8 days in jail. Michael did 25 years. But Michael's quite an extraordinary guy, and there's all kinds of documentaries and literature on this particular case, which completely changed all the rules for discovery in the state of Texas, and hopefully, and other places across the country. Race. What can we say about race? It is the original sin of our country. It is the key factor in trying to figure out how we can change the criminal legal system in the United States to approach fairness. We are all hopefully coping with this, not just coping, educating ourselves about this in a very serious way today. I talked about the CODIS system, where a database that helps you identify who committed the crimes with hits through DNA, but AFIS, which is getting better. And only 6 states right now authorize AFIS tests. That's the way that Archie Williams got out of jail. We finally got an AFIS hit after all these years. But I think it was because of America's Got Talent, the Assemblyman Lackey, who would not hesitate to tell you that he is a conservative Republican, has introduced Assembly Bill 760 in the California legislature that would explicitly authorize AFIS searches in California. So support that. The other thing I want to briefly discuss with you is what is known as the George Floyd Act. And this is the bill that is passed out of the House of Representatives. It was the the Booker-Harris bill in the Senate. And this is what's coming up as the major piece of reform to deal with the issues of police accountability and race. And it has different parts to it. And I'm going to just at some length discuss one of them, or 2 of them. One part calls for a national police misconduct database, which means that there should be one central database that identifies police officers who have been adjudicated to have committed acts of misconduct in their states, and should also be a federal database for that. The point I want to make to you right away is that whatever is going into that federal database is no better than what the states upload to it. And as you'll see, and it may be counterintuitive to you, that many states do not collect this data. The leading states collecting it are Florida and Georgia because they have very good freedom of information laws and they track it. California has been way behind the curve and we're just beginning to make some progress in the state. The second part of the George Floyd Act that I'll address with you is what we call police decertification databases. So you can track the misconduct of the police, and we should do that within the states and within on a federal level, so we can learn from those acts of misconduct and what to do about it. But also, there's something called police standards and training and statutes in most states, not yet really in California, that certify, they license a police officer. One of the critical solutions to all of this is that every police officer should have a unique identifier. You might be surprised to know that badge numbers are not unique identifiers. It's very hard to keep track of police, and you can't manage what you can't measure. But every officer, as a professional, ought to have a license so they can be uniquely identified. And then if there are acts of misconduct committed, then you can have your license taken away or suspended, right? And there ought to be a state law system that has a very clear standard for what should require, would be involved in decertifying a police officer. And in California, you are lucky. Last session, it was called Senate Bill 731. This year, I believe it's Senate Bill 2. But I believe California has before it the single best bill in the United States. It will create an oversight commission that includes impacted individuals. Will include significant civilians who have important information and ought to have an oversight role, such as district attorneys, defense attorneys, informed academics that would be part of this, as well as high-level police officials and middle-ranked police officials. And this board under Senate Bill 2 will review all allegations and then adjudications of misconduct against police officers, keep track of it, and if necessary, pull their licenses. This bill will provide, of course, for due process, for appearances before administrative law judges and appeals of this, but that is the best way to do this right now. Senate Bill, the George Floyd Act also talks about specific kinds of police practices to be reformed that you all know about, no-knock warrants, chokeholds, recommends de-escalation things. There's a group called Noble that tries to help train officers that see that a colleague is doing something that is an act of misconduct to the good officers should not be afraid of the bad officers, and we should train them to do interventions so you can avoid these kinds of situations. And, you know, training is not in and of itself the answer, because no training was given to the police officers in Minneapolis, or training of this kind. And it still didn't allow the other officers, or didn't get the other officers who were with Derek Chauvin to, in Jerry Blackwell's words, get up and let up. I think you'll hear that phrase a lot in the closing argument. And then finally, the whole issue of qualified immunity, which is a legal rule that essentially says that when an individual is harmed, their civil rights are violated by a police officer, when you bring a lawsuit, if the police officer acted in good faith, that there should be no, the individual will not be allowed to recover against the entity that employed the police officer, or certainly the police officer individually. And that is going to be the most controversial provision, although you know, the state can do something about that in terms of qualified immunity. Colorado just did, a number of others. But the best way to do it is to pass this bill and do it on a federal level. And by the way, it's something that certainly conservatives, the Cato Institute, lots of others have been fighting to get rid of for quite some time. It's not just a quote unquote progressive demand. So I'm going to talk just a little bit more because I'm now at the, how many minutes are gone here? 40 minutes. I've been talking, and I'll quit at the 1 hour part. But I'd like to talk to you a little bit about police misconduct databases and post-decertification statutes in California and across the country, and share with you that a number of us, I still have my California bar card, we're working together with defenders, innocence organizations, and the press and universities to try to create a system of databases that can help with this process. And for a long time, there were police misconduct records. I mean, I'm talking here about adjudicated acts of misconduct by a police entity against an officer were kept confidential, and you really couldn't get access to them in many, many states. And here in blue, New York and California had the two worst laws, right? In New York, it was called 50A, where you couldn't get any access to police misconduct data until the eve of trial. And then, and only 3% of cases ever go to trial. So even among those cases, it's very hard to get access to those adjudicated acts of misconduct, even in the context of a trial. And then there were other legal hurdles to finding it out. And in California, it was known as Pitch's rule after a case. And that wasn't true. Well, here's Pitch's. That's I give you Pitch's and 50A in this particular graphic, a kind of famous picture. And so I've written something not too long ago as a preface to the Georgetown Annual Review of Criminal Law, but a lot of us have been thinking that what really ought to go on now in the United States and every part of California is that this police misconduct data ought to be a matter of public record, would be for other public employees. We're not talking about revealing social security numbers or medical records or anything like that, but we're just talking about police shouldn't have these special rules that prevent access to the information. So there should be a public database that contains adjudicated acts of misconduct that is known by the DA, the defense, and the public at the time of charging, not at the end of the case. That's the way it ought to be, a public database. There should be a defender database with all the information at the that you would be in the public database, but also what we call work product information from clients, from lawyers about police officers, disclosures that you get under protective orders, and things that investigators would find. And then there should be a prosecutor's database, because they should be doing the same thing, and they do the same thing, to really get oversight of officers. If you really need to know anything about the importance of these acts of misconduct, what do all these people have in common? Derek Chauvin in the George Floyd case, Detective Van Dyke in Chicago, the man who was convicted of shooting Laquan McDonald, the officers that shot Tamir Rice. I could go on and on and on. Eric Garner, the person who was strangled in Staten Island, New York. What the theme that goes through all of these cases is each and every one of these officers had undisclosed acts where they had been adjudicated to have committed an act of misconduct, and lots of other allegations against them that were considered, quote unquote, unsubstantiated as opposed to unfounded. Because if you have lots of, quote unquote, unsubstantiated allegations, which really means in the context of civilian complaints that whoever was reviewing it decided that it couldn't be the it was not more likely than not. It was the word of the officer against the person making the complaint, and they couldn't reach a decision. Those unsubstantiated are obviously something extremely important to see. And then, of course, there should be these post-certification decertification statutes in every state. Doctors have these, and insurance companies help make that work. It should be all across the country. And as I told you, Senate Bill 2, pending in California now, is the best statute I've seen in the United States. Just to give you a sense of how important this is. This is what most lawyers' offices look like before the digital age when you're looking at cases. And here's the city of Philadelphia. So on the right is our friend Meek Mill, and Meek Mill got out of jail. And people want to know how did that happen? And it turned out that the police officers that were involved in the original arrest of the Meek Mill case had prior bad acts. And on the left is my friend Bradley Bridge, who is a longtime public defender in the city of Philadelphia, who personally was institutional knowledge. And on more than one occasion in his career, Brad Bridge has gotten literally hundreds of criminal convictions vacated because he realized that the officers involved, what would happen in Philadelphia, it happens in New York, happens in Chicago, happens, I'm sure, in Los Angeles, all over California, all across the country. But in Philadelphia, there are a number of times that police officers, particularly in narcotics cases, were indicted by the federal government and convicted. And it became clear that at a certain point in time in their career, these officers had become criminals and were not worthy of belief. So what Brad did is he went to the prosecutors in Philadelphia. He said, I have 140 cases here where these particular officers and their networking groups were involved in the conviction of these clients. Their conviction should be vacated. And if you have any other independent evidence to charge them, be my guest. But you can't, these convictions cannot stand, because we now know that when these individuals were convicted, the police officers involved were literally engaged in criminal activities, which show that they were not worthy of belief. Here's our friend Josh Tepper from the Exoneration Project at the University of Chicago, one of the members of the Innocence Network, and people from the conviction. Mark Ratot is the man who's, I guess he's losing his hair a little bit to my right on this picture. And this is an exoneration in Chicago. There have been 73 and still counting exonerations in Chicago, thanks to District Attorney Kim Fox for her Conviction Integrity Unit in doing this work. But these all arise from the Detective Watts scandal. A detective, again, who was convicted by federal authorities, and they're just going back and looking at those old cases. This is Detective Scarcella in New York, the Brooklyn District Attorney's Office, the late Ken Thompson, and now his successor, Eric Gonzalez, started their own conviction review unit to look at Scarcella cases. There's my friend Derek Hamilton on the right, who was wrongfully convicted in a Scarcella case. He's a great jailhouse lawyer himself. And in going back over these old cases, all kinds of people have been exonerated. In the first 2 years that Ken put his unit together, there were, I think, 28 exonerations, but virtually all of them were in homicide cases, and they did not involve DNA testing for the most part. Here is, I think, personally, the worst civil rights case going on in the United States. In the middle is my friend Cheryl Pilot, longtime defense lawyer, capital lawyer in Kansas City. And Cheryl and I, a long time ago, worked on the Ron Williamson and Dennis Schritz case, which was part of a Netflix movie, if you've ever seen it, called The Innocence Man. It was the only fiction book that John Grisham ever wrote, but Cheryl worked on the civil case there. And Cheryl has been leading the way because to the left, there's a detective there named Golubsky, Roger Golubsky, who we have alleged in our civil rights firm working with Cheryl, Neufeld, Scheck, and Bruston, has been oppressing women, sex workers in particular, working with narcotics dealers in the city of Kansas City, Kansas, for very, very long periods of time. And Golubsky, we allege, framed the man to the right, Lamont McIntyre, and there's his mother, Rose, for a homicide that Lamont didn't commit, that was committed by people who were working for drug dealers in Kansas City, Kansas, and Golubsky was involved in covering all that up. It is a horrible, horrible, horrible case. Lamont was exonerated. I'm not just using these words lightly. They passed the Lamont McIntyre law in Kansas to compensate wrongfully convicted people. And we do have, so you know my interest in this, a federal civil rights case in Kansas City, Kansas. You can look up all the things that are going on there. And I truly hope that the Department of Justice will come in with the Civil Rights Division, whatever happens in our case, and do one of these consent decree restructuring of the police department in Kansas City, Kansas. These are the kinds of things we have to do. Finally, there's one of our cases most recently in the Bronx, Hugh Burton, who gave a coerced false confession and was framed by police officers from the 47th precinct. Somebody else is doing this civil case. But again, we want, and the Bronx District Attorney's Conviction Integrity Unit says it's at work on this, to go back. Hugh was convicted in 1989, same year as the exonerated 5. And his case, in my judgment, and another case that preceded it, this was really criminal activity by these police officers. And we have to go back and look at all those old cases. One of the things that has helped along these lines is that people that I'm working with who used to be at the Legal Aid Society of New York have developed, before we had any access to the misconduct information, they began using technology. And what they were able to do is scrape overtime data, which was public, things from social media, what they call Brady letters, admissions by prosecutors that the officers had committed misconduct in certain cases, or they've done things that ought to be subject of impeachment. They would get things off PACER. That's where you civil rights cases and state and federal court decisions are out there that bear upon the police officers. There are other decisions where they talk about them. Anything you could get in those days before the repeal of 50A, which happened right after George Floyd's death. And they would take all of this and they would put it into a database. So each public defender walking into court could look at his or her cell phone, and they would be able to see all the information that could be gathered by on the police officers. And just think about it. So we're trying to take this database, which tracks people and groups and content and incidents, and have defenders in the state of California be able to do this. And we're working with the defenders, and we're working with people at the Data Science Center at Stanford, at Berkeley, and journalists at Berkeley and Stanford in trying to build these databases because they're extremely important. Here is, because the impact of gathering this data is extraordinary. If you know about the misconduct data at the beginning of a case, It could lower bail. It could result in lower charges. It will expose, when you keep track of it, officers that are lying. And if you catch one officer in a lie or have a video, right, of the officer plainly lying, then what happens is that every defense lawyer ought to know about that, so that and every prosecutor, so that the cases that those officers made can be appropriately adjudicated. It certainly guides investigations and it improves outcome. I like to call it a virtuous cycle. You do a defender database and that creates all kinds of reforms. But beyond that, and that's what happened in New York, the defender database, I believe, led the prosecutors. There's our friend Cyrus Vance, who began demanding more information from NYPD, and eventually coalitions got together and 50A was repealed. Another way of looking at it, and incredible work, go to a website of the Invisible Institute in Chicago, and you will see the Citizens Police Data Project. And this, our friend Jamie Calvin, who was the executive director of the Invisible Institute and a great journalist, the one who exposed the tape in the Laquan McDonald case, he and his colleagues have formed this terrific public database where when you literally, the public can see all this information. And that is a model, extremely important model, because the press plays a huge role in it. And the public data, again, can lead to defender databases, data in court, DAs creating their own databases, media, and eventually, the police using this information, and legislation. And in California right now, there is a story where the press got together to pass what was known as Senate Bill 1421. It was a coalition of, this was the bill that passed the last session. It should be improved. I think it's now Senate Bill 776. Senator Skinner from Berkeley was leading the charge on this. But the way this happened is very important. Is the last thing I'll mention about this. There was an article in the Los Angeles Times. And in the Los Angeles Times, they had a secret list of hundreds of LA deputy sheriffs who had a history of misconduct. I'm talking about putting blood on their, putting Tabasco sauce in their shirts and saying they were bloodstains, to sexual harassment of civilians within the police department. But basically, the sheriff's department said, we don't trust these people. We want to send letters, what are known Brady letters, to the Los Angeles district attorney, so they'll know not to use these people in cases, or to at least reveal all this information. And when they tried to do it, the police unions moved to enjoin them, saying under the Pitches statute, they were not allowed to do it, that misconduct information could only be revealed just on the eve of trial by a judge in a very narrow kind of procedure. And that is, and the union won. They won. And this was caused a lot of, understandably, concern. And they passed Senate Bill 731. But unfortunately, there were only 3 buckets of information in that bill. Any acts of dishonesty became acts of public record. Any instances of sexual misconduct. And then you could get information about police shootings and serious bodily injury cases that were historical from a long time ago. Were all subject to Public Record Act requests. But you had to go out and get them. So the Peter Bybring and the ACLU in Los Angeles really led the way. And right now there are 40 newsrooms in California. They call it the California Reporting Project, which has been filing Public Record Act requests, gathering the information so that we can have a public database in the state of California that can be of benefit to prosecutors, defense lawyers, researchers, and impacted people in communities. I hope eventually we'll all have your help in that. So I am going to stop right now. I think I've covered a lot. If I went too fast, I apologize. And I'll turn it over to my friend, the great Reggie Williams, so we can engage in questions or dialogue.
Thanks, Barry. The only thing you said that was wrong is that I'm great. But no, thank you so much. Your talk was amazing. So much content. I thought the pace was really nice too. So thank you so much. Really appreciate it. I've already kind of glanced at the questions, and my take on them is they cover a lot of worthy territory. So I'm inclined to just read them, and we'll get through as many as we can. If I don't get to a question for the audience, if I don't get to a question right now, you come back at 6, because I'm going to keep these questions. And if they pertain to 6 o'clock, the 6 o'clock talk as well, I'll keep them and kind of front load them and so forth. So keep that in mind for the rest of the day. All right. So the first question, chronologically speaking, was sure enough the question that we had already anticipated when we chatted on Monday. So I'm going to go ahead and ask it and let you field it. And then there's such a range in terms of the questions. So the first question was, in retrospect, do you have any qualms about working for the defense team in the O.J. Simpson case?
No, but you know, it's important to know how that all evolved. At the time that Mr. Simpson was being investigated, everybody knew that myself and my partner Peter Neufeld had a lot of expertise in terms of serology and DNA testing. So we were asked to be part of the defense team to advise the great Jerry Ullman, who was the dean of Santa Clara Law School, and others in trying to evaluate the evidence at the preliminary hearing. And by the way, it's kind of nuts that the DNA test results did not come back until February and March, the complete set of results. And the jury was selected in January. I think it was 1995. The incident was in 1994. But you know, we were part of that team, and you know, we did what a criminal defense lawyer is supposed to do. Now, what's interesting is that the prosecutors in that case, one of them, the late Woody Clark, who went on to become a judge in San Diego, and unfortunately, really terrible that he passed far too early. But Woody and the Alameda County prosecutor who were helping the prosecution team were DNA experts. So Peter and I knew Woody and Rock very, very well. And actually, particularly with Woody and some extent even Rock, had a lot of agreement on certain technical issues having to do with DNA testing. And the fact of the matter is that the way that the samples were collected and processed in the Simpson case were a disaster. The crime scene was handled all wrong, and that there was a lot of contamination in the Los Angeles Police Department lab. And all I can do is refer you. Lots have been written about the Simpson case, but Jeff Toobin wrote the most popular book about it, The Run of His Life, I think he called it. And he has a chapter on the work I did there with Peter and others, that he admits that we raised a lot of great points that were very important, and that we did come up with a consistent theme and explanation. What happened after the trial is most significant because the Simpson trial did, I think everybody agrees, change the way that crime scenes were processed. You can't have a 21st century or 20th century technology like DNA and have old techniques for collecting the evidence that can cross-contaminate it and do things that everybody would agree today, the way it was handled in the Simpson case was all wrong. But what are you going to do to change it? So what happened is Janet Reno appointed a commission on the future of DNA evidence. And I was one of the commissioners, and so was Woody Clark. And we came out with a series of recommendations. And one of them was a pamphlet called What Every Law Enforcement Officer, we had one thing, What Every Law Enforcement Officer Ought to Know About DNA, how to pick it up, collect it, all the things that were done in the Simpson case that were done incorrectly, putting wet items into plastic bags, which will degrade them, et cetera. But Woody and I then worked with others on something called Recommendations on Post-Conviction DNA Testing, which gave best practices for prosecutors, for defense lawyers, for crime labs, for victim services people, you name it, across the board. And that turned out to be an extraordinarily helpful pamphlet. It wasn't more than a pamphlet. It was a publication of the US Department of Justice, National Institute of Justice. And what we wound up doing, very soon after the Simpson trial, when this came out, is we were calling people across the country saying, please take a look at this set of recommendations from the National Institute of Justice. You should be consenting to DNA testing in these cases, even though there's no statute authorizing it, even though in theory we're not allowed in court. So that worked out very well. And that's one of the things that I would really note about the prosecution in this Derek Chauvin trial. For better, I realize a lot of the verdict in the Simpson case was controversial. I think that the work we did, as defense lawyers, certainly around the forensic evidence, was very useful. And the one thing I'm sure of is it changed the way everybody did business in the criminal legal system and certainly in the crime labs. And that, a prosecutor like Woody would work with us and other prosecutors across the country in changing the way things were done. And I do believe that when you look at the testimony of the pulmonologist Tobin, the cardiologist in the Chauvin case, and the way that the prosecution team approached this case. And these are, the prosecution lawyers here, two of them are civil lawyers, right? They're not criminal lawyers. Tobin himself, as I mentioned before, apparently had never testified in a criminal case. So when you're dealing with these issues of in-custody death, whether it's in prisons or on the street, this case will change the way everything is evaluated and will change the way these cases are tried for the good. The Simpson case didn't do very much good for race relations in the United States, but in the area of forensic science, it definitely improved matters because, people in the system can learn to work together and get to the best results. And we did have that partnership with Woody and others.
Awesome. Thank you, Barry. Next question. The Niffins and McQueens were people who were the first to be named in a notorious child molestations case/ring. Later, they were determined to be wrongfully convicted. It was determined the way the children were questioned was very, very misleading. My question is, in your opinion, how long does it take for police agencies to change from a negative systemic, from their negative systemic point of view?
Which case were they saying, the McMartin case?
If I'm pronouncing it correctly, the Niffins, but spelled with a K, and McQueens. And I don't have the context. This may be a reference to a local infamous case. It may not be. I don't know the names. But certainly Kern County has been featured in a documentary film titled Witch Hunt. It was profiled because roughly off the top of my head, I believe it was the early 80s. We had 18 people convicted and later completely exonerated for child molestation in Kern County, the greater Bakersfield area. It's an infamous case. The ones still alive and such got released. Sean Penn did the narration for the documentary because he believed so much in the process and so for the cause. So it may be a reference to that local ring, alleged ring that is, wrongly alleged ring, or it may be from a different area. I'm not sure.
Well,
That's really just a setup for the question.
I may have this wrong, but I think that our colleagues, Linda Starr and others at the Northern California Innocence Project might have had a client that was enmeshed in this from the area, John Stultz. But, well, there have been a history, there's a long history, unfortunately, of these kinds of, some of them even came into involved beliefs about Satanism, right? That there were these child molestation rings that engaged in not just molestation, but even acts of Satanism. One of them, very famous California one, the McMartin case, where a number of wrongful convictions were discovered. North Carolina, the Little Red Schoolhouse case. We had a Bronx daycare case. I could go on and on. Recent Innocence Project case involving our clients Hardin and Clark in Kentucky were victims of this. So there's been a lot of these kinds of cases. And what arose after each of them is hopefully there are requirements on how you interview child witnesses, videotaping them, trying to avoid suggestive questions. There's a whole problem of cognitive bias in these kinds of matters. And I do think that in the whole area of child abuse, we have to be extremely careful about how those cases are done. And there are, lots of best practices that people have developed. It's still one of those difficult areas, even in the whole issue of what's known as Scheck and baby abusive head trauma. There's a tendency where what the cognitive sciences would call domain irrelevant information begins to get processed in the work of the investigating officers or the child abuse teams or the prosecutors. And I think that is one of the main areas that we have to look at if we want to permanently improve these systems.
Thank you. A couple of questions. I just got another one, so I have to scroll up. A couple of questions dealing with the Minneapolis situation. Why do members of the Minneapolis police, why have they been willing to testify for the prosecution in the Chauvin case? Do you think the defense is grasping at straws or that they can raise reasonable doubt?
Well, the reason that the police chief and everybody in the police department from the top down, came forward and testified is that, and I'm just quoting their testimony, is that Mr. Chauvin's conduct was outside of training, right? And I think one of the great policing experts is Seth Stoughton. He was the last police training expert that the prosecution called. Seth and his colleagues in South Carolina have written sort of a major treatise on policing, and he was a prosecutor and is also a lawyer. I commend his testimony particularly to your attention about police practices. But, the reason that everybody so testified is that this is way outside the norm. I mean, believe your eyes. It is simply not appropriate under any set of circumstances to have somebody in that prone position, which has been known for years to create positional asphyxia, to just even be sitting on their back, pushing on their back, as all the testimony has shown, as a known danger of cutting off oxygen and killing people or causing serious brain injury. But to have a knee on the neck at the same time is really beyond the bounds. And that's why you found the police chief and police officials all across the country. I think it's a consensus view that what Mr. Chauvin did is wrong, and it's a violation of the Constitution, and plainly is criminal. He's being charged with various different degrees of murder. I think that, as I indicated to you, I think that this was a singularly well-tried case. I think the prosecution put on a great case. I have no particular criticism of the defense lawyer at all. I think he tried to do what he could under the circumstances, but we'll see what the jury does. You can never tell, but I think they've presented an overwhelming case. But beyond just an overwhelming case, the way they put in this evidence and dealt with the science and the training procedure, I hope is watched by it's being watched all across the country, and I hope this will lead to changes. If people really take all those suggestions from the experts seriously and really begin to look into the scientists, particularly what the pulmonologist, who was an incredible witness, said, that should change the way these cases are tried. Both a lot of these cases, by the way, also arise in correctional institutions.
Nice. Next question builds on that in a kind of interesting way, taking it slightly differently. So same case, given the country in which we live and the city in which this case is taking place, I've heard that Chauvin could still get off lightly. In your opinion, what is the likelihood of his not getting prosecuted? And if he does get off lightly, what would that mean for the future of holding police accountable for their treatment of citizens during arrest and otherwise?
Well, I think it will be all that you can really ask of criminal people in the criminal legal system is that they do their jobs correctly. So I'm telling you that the prosecution case was put on brilliantly is not too strong a word. And I'm really comparing this, very often prosecutions of police officers are extremely difficult for prosecutors because, they work with officers all the time, and sometimes it's hard to think outside the box. I don't think it's an accident that Keith Ellison, the Attorney General of Minnesota, was widely respected as an absolutely terrific trial lawyer and had done a number of defenses in homicide cases in his career. And he had the foresight to bring in people, Jerry Blackwell, Steve Schleicher. I apologize to him for mispronouncing his name. He's a great lawyer, and all the people that they put together in the teams. And I don't mean to derogate in any way the career deputy attorney generals in the office, but the fact that they brought all these people together and really thought it through and went and did a true scientific analysis of everything, looking at people from different disciplines was extremely helpful. The medical examiner, Andrew Baker, who was widely respected, and understands the issues having to dealing with cognitive bias. Dr. Baker indicated, look, I am not a pulmonologist, right? On these issues of asphyxiation and, what was going on here in terms of oxygen loss, I deferred to the pulmonologists and I deferred to the cardiologists. And that is extremely helpful. That's what should be done by people investigating these cases and trying them, whether in the criminal cases or civil cases or internal investigations. That is the kind of information we need. this nonsense that, oh, if I'm on top of somebody in a restraint position and they're prone and their hands are handcuffed behind their back, and they're still talking, well, that means they're alive and we don't have to worry. That kind of training, as all the witnesses for the prosecution pointed out, kills people.
Much appreciated. Next question. You mentioned earlier the excited delirium defenses not being so prevalent following this case. What do you mean by that concept, that kind of defense?
Well, as you heard from the testimony, leading medical associations and scientific associations have denounced this notion of excited delirium. And basically they actually, prosecution went through the elements of excited delirium, as they're called, with a witness who I think actually believes in it, but made clear it wasn't operative in this case. But I think essentially, and a lot of this has arisen in taser litigation, the idea is that there can be a sudden secretion of adrenaline as somebody is being restrained with a taser or in some other fashion, and that the sudden surge of adrenaline can cause mental states that are delirious, or it happens to people that are in such mental states, and all of a sudden people can have super strength. It arose in the context of frankly the Rodney King case, but a lot of it has arisen in this taser litigation, and I think it's a kind of defense that lacks real scientific merit. I believe that, so I think that's bad enough.
No, awesome. A different kind of question. Does the great work that the Innocence Project has accomplished call into question the ethical practice of our criminal justice system at large? For example, if our prosecutorial methods are committing type 1 errors at rates much higher than even the Innocence Project can demonstrate, doesn't that put the whole system on less solid ground?
Well, of course. What with the Innocence Project and our colleagues in the Innocence Network and in the Academy and, in a lot of policing entities. I mean, we've had enormous support from police. So you want to reform these practices. Of particular note, there's, for example, we now have videotaping interrogation in most states and the federal government, but what the science shows us is that there shouldn't be deception used. Police should not be saying, "Oh, we found your DNA at the crime scene." That's unduly coercive. It doesn't lead to reliable admissions. We should be considering reliability when we look at whether confessions should come into evidence. Unfortunately, the U.S. Supreme Court has said that we only look and see if they're voluntary. We don't look to see whether the confession is reliable, is corroborated by independent evidence, has led investigators to information that only the real perpetrator and the police would know. So we've made some progress in the area of false confessions by at least having it videotaped, but deception is the next big step for us. So lots of these things have changed. But when you're talking about the ethical issues of how law enforcement operates, what you ought to do is look at the registry of exonerations issued a really important report this summer on what they call official misconduct. And if you go to the Registry of Exonerations website, again, connected with UC Irvine, and you download the report on official misconduct, I think that you will get a really well-informed and important answer to your questions, both documenting the extent of the misconduct and to what extent we have a real measure of it, and also reviewing a number of areas that would be important for reform.
It's 11:29. Do you want to take one more that could potentially be concise, or would you like me to hold? Yeah. Okay. Let's do one more. And then again, if you have a question that I didn't get to, I'm holding them on my phone for tonight's talk. And assuming they're still relevant, I'll be happy to start with some of these. So come back, audience appeals. For the final question right now, in your opinion, has DNA been the biggest scientific advance associated with your career, the Innocence Project and such? And if not, then would you?
Not just my career. I mean, I think that Peter Neufeld and I were just very lucky that we happened to get involved and take an interest very early on in the transfer of DNA technology from medical and research applications to the criminal legal system. So we were, got to know a lot about it. We were very, very lucky that a case that we did challenging some of the problems, there were quite a number of problems with the forensic DNA applications. And we tried an admissibility hearing in New York, and our principal witness and guide through that was Dr. Eric Lander, who, as you may have noticed, is now President Biden's official science advisor, and was involved in mapping the human genome. So we were just very lucky people who got to know, some brilliant and extraordinary individuals in this whole scientific area. And I guess because we started as public defenders in the Bronx, we kind of knew the system was screwed up. And from the beginning, we knew that DNA would not only lead to the apprehension of the guilty, but would lead to the exoneration of the innocent. And truth be told, we knew how bad this system was because we were public defenders, and we could see it firsthand. So, we were the right place at the right time.
Much appreciated. I want to say a huge thank you to Barry Scheck again. I really, really appreciate your talk. It was fascinating. Looking forward to another one at 6 p.m. tonight, Pacific time, West Coast that is. So please join us again at 6 o'clock. Again, if I didn't get your question just now, there's some other great questions that I presume will still pertain. So I will be looking those over and planning on reading some of them. So come back to hear your answers. And of course, we'll get some new questions tonight as well. So again, thank you so much to Barry Scheck. Really appreciate your time. I know you're busy, but an amazing talk, and we'll see you in a few hours. And tell friends and so forth to come check it out tonight, 6 p.m. Have a good one. Take care, everybody.
Okay, take care.
Thanks, Barry.